You're accommodated. You're accommodated.
Yes, my lord, but direction has to give regulation, my lord. Division bench, single bench, everybody has. Which will give the continuity of service. From the order of the principal secretary also reflects, which will give the continuation of service. Of course, they will not get the salary after termination to the reinstatement. Although order is from 1st April 22, he has been given salary from 2020, 1st November 2020.
Yes. Yes, Mr. Bora.
But man just keep everything, Melo.
Hmm?
Yes, keep everything, Melo. They are not projected the case that it should be, Melo. One of these petitioners were appointed in a non-central. Ultimately, in 2019, 2012, they were terminated, along with lots of other posts. But this particular petitioner didn't approve the 8 petition. Large numbers of 8 petitioners filed. Termination was upheld because they were all appointed in a non-sanction. And ultimately, it ended up the writ appeal number 182, where in 182, PTC authority has said there is a policy decision will be taken and there will be recognized no person taking salary up to particular date. And accordingly, given. Simultaneously, there is another set of petitions, petition number 59 of 2013. These people has also changed, still in the order. But these people who have in petition number 59 of 2013, they were working in a sanction. And ultimately, in that particular case, when judgment was delivered on 28/11/2017, that issue came up before the court that there is another, there is a repeal dispose of a policy division. The authority in the PTC will verify whether they fall under the sanction post or non-sanction post or another or as per the order of the DTP. In view of that, they have authority in the PTC have to decide. They are verifying everything. Thereafter, my lord, authority verified everything, and lordship will turn to page number, my additional affidavit. The order will start from page number 7, annexure 2. This is order dated 25 April 2019. Lordship will find in the second line itself. In the judgment order dated 28/11/2017 passed in Bhagavad High Court in WPC number 59 of 2013. Another set of persons who were appointed in the sanction post but also terminated. Now, everything has been discussed, report has been discussed, and what will now turn to page number 76. Ultimately, what the authority has found, this set of persons are sanctioned working in a sanction post, and they are not similar to the persons which were terminated. We are not working the non-sanction post. What will turn to page number 76, second paragraph, while considering the present petition, whether the case are covered under the policy decision of PTC referred in April number 182 of 2013 batch, it may be stated that the case of the present petitioner, public teachers, and that of the teacher referred in the April 182 stands on different footing and complying with the direction of one are completely missing from one another. In the case of April number 182 of 2013, that the appointment of the teachers are not to normal selection process. As no advertisement, publication, or selection conducted. No prior approval of the aspect BSc authority was obtained, etc., which were undoubtedly not the basic feature of the case of the present petitioner. The present petitioner instead of went through a selection process as per the government rule. Therefore, as per preliminary observation, the petitioners do not fit under policy decision of PTC under April 182 2013.
Which 59?
59. They want the similar treatment along with 59. 59 is the selection process. It has been done. So this particular order has been first, they were taken back. So these they don't come under 59. They come under, in fact, if lordship turn to their
Where is the judgment of 59?
59.
13 come for-
But Martin, this is all, our website has been printed, but this is not the accurate document on the website.
My turn.
Is there any reference of Writ Appeal 180?
But last page, now, after the last paragraph, they have to verify whether they fall under the ETP. I have marked that particular paragraph, the last paragraph. Last but one. Refer to the directed to verify whether they fall under the same category of ETP 182. Then the order was called verification order was. Last paragraph was verified.
This Writ Appeal arises out of which writ petition?
There was a series of repetition, my lord. I mean, the certified copy of the repetition.
Is 2152 a part of it? WPC 215,
2152.
no, is it a part of that? Writ Appeal?
No, 2152 is something completely different. These are non-sanctions. And this 59 is the sanction post.
No, why don't you bring it as a part of the record? Make it a part of the record. All these relevant judgments and orders,
That's the minimum.
so that we know from which judgment, which matter is connected to which judgment.
In fact, when a lawsuit comes to their own repetition, their repetition itself says that they are connected to Writ Appeal 82.
So in this writ petition, there is a finding by the court that it is covered by the order of the writ given appeal.
So there is a submission. Then they said that if they have to verify last paragraph whether they come under this Writ Appeal or not. So there are two sets of persons, one is non-sanction, another is sanction. These petitioners are from the sanction post. Now
But sanctioned or not sanctioned, how is it the appointee's responsibility? They appear before a selection. They are selected, they are appointed. Whether this post is sanctioned or not sanctioned, how will it? It is for the authority to
Yes,
decide.
sir. Thereafter, my lord, page number 70, the authority has decided on the.
So how can you make a distinction between sanctioned and non-sanctioned post? You have
Yep.
given them appointment. Where the court has taken court has taken a decision that the policy decision will cover. You are only to ascertain whether
Ascertain.
the appointments were made on the basis of select list and against sanction.
Yes, we have ascertained, my lord. Thereafter, my lord, the order has been passed. But
Now,
part
if
of the
you- if
record, my
you-
lord, I have annexed to
the-
my affidavit.
If the authorities were of the opinion that it is not against sanction posts, why did you give them appointment now?
Because there was a policy decision, my lord, to give, thereafter we took sanction, then they were appointed.
Policy decision is to take back the terminator.
The policy, we have, because policy decision is appointed without sanction. During the
Policy
interview,
decision is to take back the terminator. Once
Because-
you take back, whether you put them in sanctioned or non-sanctioned,
Yeah.
you have to decide.
yeah,
But
thereafter,
where the policy has taken a decision to take it back, means they are deemed to be in
my lord, that the SI will have to be given. SI will
Never
came
approval.
after the writ appeal order, my lord.
Policy is taken by who? By the captain.
Yeah.
So can the administrative authority go beyond the captain or they proceed in the manner that it shall not be completely after it is taken. The highest has to be implemented.
What has happened, my lord, in the writ appeal,
Where
they
is
challenged the termination order.
where is that cabinet memorandum?
Policy, where later on it was a policy decision of, first of all, they filed a writ petition challenging the termination. That was appealed. It was
Do you have the policy?
right now.
What was the
Then that policy decision,
from the order that appeared that it was take back the terminator?
especially termination, the person up to the person who having a service up to getting his salary at a particular day,
2006.
2006. That at that particular point of time, even sanction was not there. Sanction came later on. Then we started appointing them. Because you have to take a financial sanction. Financial sanction was not there. Even financial sanction was not there, that there a review petition was filed by the finance department in the seat appeal itself. But till that, the financial decision was not there.
That's what happened.
Review petition, ultimately, during pendency of the review petition, the financial sanction was granted. Thereafter, appointment started. 1009% sanction was given. Percent. Then the appointment started. From there itself, my lord, the petitioner got the appointment. If lordship turns to they came before the court. If Lord takes up, my lord,
No, but
the repeat.
if the decision to take back the terminator, then we need that the petitioner services are required. Now, if the state does not have that many number of sections, proper proposal is happening.
Yeah, that was sent. Thereafter, we got the sanction for 1009 post. Thereafter, this petition.
Including the petition.
Yes, including the petition, another 1009 posts were created, my lord. Then they got the appointment. Because this particular petition even didn't challenge the termination order.
All right.
Some set of person has targeted a
Now-
termination.
Now,
We are adding on the division bench order, my lord. When they came before the court, even division bench order was passed.
now what are your prayers here in the writ petition?
To get the pair. Lords will turn to page number 12. They want the pension from the old pension scheme, not the fresh one.
According to you, they'll get it from which day?
From the date of their, prospectively, from the date of their appointment, Lords will turn to page number 49. 1st April 2022.
22.
22.
When are you retiring?
Up to next month.
No, affidavit will make it clear, my lord.
You are 47 years.
47 years.
47 years.
On 20,
Another 13
48.
years left.
Huh?
14 years left.
13.
60 retired, my lord.
What will be the financial
What-
benefit to the petitioner at the age?
They will get all the whatever the salary is there. Even Lord's other day, my lord, I have shown that when the policy decision is taken on the based on similar cases, my lord, similar Supreme Court judgment, my lord, lordship have handed over on the other day, my lord, that it should, that any appointment by the policy decision should be prospective. Not, it cannot be on the basis of retrospectively, my lord.
Police decision continuation is given.
No, policy decision. That is why we say that the policy. Where is that? Cabinet memorandum?
No, sir, I have to get hold of that particular record.
Bring it on record and keep all the judgments which are, you think are connected or relevant, because we'll have. It will call for a reference to the various orders passed by the. Assuming there is a distinction between one order passed with the order passed. With the appellate. Appellate court order is here.
Appellate court, I have
No,
had
that
an
is-
additional affidavit as to- in the appellate court order.
Appellate court order is very clear. Policy decision taken that person receiving regular salary from the month of March 2006 will be regularized. So what is the meaning of regularized?
Will be regularized as per implementation of the policy. Policy, ultimately the policy.
Exactly.
Important.
Regular appointment will be given.
So what is the policy? What is the policy? PTC and government took a decision to regularize all those teachers who are in service and are regularly receiving salaries up to 1710. It's a policy decision to regularize.
Decision to regularize. Thereafter, we have sent it to the SI approval.
So SIU, if they do not approve, they cannot change the policy decision. They are bound to comply. Once a policy is taken by the state at the highest level, they are bound to comply. Or they'll have to come up with reasons as to why it cannot be complied with. Or maybe refer it back to the policy makers to decide that it is not capable of being implemented, kindly modify.
In fact, it has been implemented. That's why they are, even they were terminated. Termination again.
Policy
appeal,
decision
They
is
were back
always-
in service now.
you're quite right. Policy decision is always prospective. But the decision itself, we don't know, it is reflected in the order. Decision itself says regularize those teachers receiving salaries up to 1710. So it has to be with effect from 1810, 2006. Policy decision is to regularize. So we want to be clear about what the policy decision
So then I have to get hold of that particular policy.
is.
May I submit my?
Yes,
My lord, learned single judge has passed the order in pursuance of the division bench order. And my lord, dear my lord, they probably did not submit anything. Now the issues, new issues.
the council had the issue of sanction or non.
That time, my lord, when the repetition was there, that issue have been taken because now it has taken finality.
Your writ petition,
There,
you're relying on
yes, man,
does not decide anything independent. It merely relies on a earlier.
division bench, yes. And division bench order also, my lord, it is a simple order.
Division- there-
There also did not say sanction, non-sanction, anything.
Exactly, therefore we need to see the policy. What does it say? What is this policy?
As your lordship wish, my lord, but my lord, the condition given in the division bench, I fully covered it. Because, my lord, I was getting salary after also, my lord, thereafter also, and my lord, I was working in a sanction post.
Cannot be sanctioned post. Non-sanctioned.
That's why he was getting scale, my lord. He was getting scale. Otherwise, you would have been, my lord, that stipendary or some fixed.
You show us. Bring it on record outside. You require.
So 3 weeks.
Yes, my lord.
Maybe policy decision has been referred to the state government and all these things.
All right, we will take it up on 27. Wait.
But my lord, it should not be tagged with any other matter, my lord. It should be independently.
It is too bad.
Two matters, my lord, I don't know his matters. My lord. So, my lord, it's
Item one,
a
item
simple
four.
question that I have been appointed as press appointment. That is my grievances. And regarding back salary also. 27,
Hearing. Question of. Taken by state. And in our. Or taken by the. Taken by state. Not part. Question of. Happening. Anything before. Of the. At the. Date of the. Do not state. Symptom. And. Petitioner. And. Teacher. Or. Covered under the repeal.
my submission also be recorded by law.
Petition. 59 of 2013. Okay.
On. In favor of every perspective. State has taken. action to regularize to. 59 petitioner have been.
Regularized.
59 is regular, that's a separate order.
They
Separate
want
order.
a similar,
Definitely.
they want a similar, which according to you cannot be given because they are. Doesn't counsel. That. The petitioner is 59 of
59 of 2013.
2013. That of different. That is different. Okay. Were appointed inside. There is. We did a. From. Order. Passed by the.
15, 7.
180 to 2013.
2013.
That. The division bench has reported. Finding that state of. That regular and. Salary. Till 1710. Claim at present. Rule of.
38 June 2008.
Policy taken by the state. That. In effect, right. Element. Like.
Carbon, even in our carbon.
7.
May.
Okay.
27. Division
Your matter is also tagged. 27 May.
That is 29 by law.
29.
His facts is the facts are different.
Whatever decide.
It's my
Let it
lord.
be on 29.
And my lord, division bench judgment dated 6 to 2015.
6 to.
2015.
Yes.
All right.
I plead the law. My lord, in fact, my lord, the pension dues has been released by the AG, my lord. Matter is pending before my lord, Treasury Officer Haplong. And due to some dissimilarity in name, my lord, Odanta Rai and Odanta Devi, they are not releasing. In fact, we have filed an affidavit, my lord. And my lord, may I pray, my lord, 2 weeks time may be granted. In the meantime, they will release, I think, my lord.
It is submitted by the learned counsel. papers that we entered DPO by the accountant general same pending. So the treasury officer
Haplong, my lord.
Haplong. And because of the change, because of the different, because of the treasury officer, after three, the matter. Third of it's a deep matter.
Obliged. Obliged. My lord.
Discussion.
Lordship, in this matter, we have received instruction. We have received the pension proposal from the concerned administrative department. And according to the procedure initiated, madam, the PP order generated, but it's not issued. Madam, they are
He
PP order generated, madam. That may,
not
not issued. And madam, they grant some more time so that we can.
but on instruction, setting up, account. Okay. But on instruction, the thing, that- that- However, has not changed the same. Update, update. Hard to
My lord. Obliged.
My lord, PP order generated, not. No. No.
you are in the general.
No.
What is the difference?
He has generated some processes there, but there. If issued, my lord, then we can issue.
Is a lordship transfer matter, there were supposed to be instructions.
Well, this matter may be disposed of, my lord, by directing the principal secretary. They have given a representation, my lord, for the principal secretary at page 28. The principal secretary may consider the office memorandum, my lord. It is at page 30. And accordingly pass a speaking order within 30 days.
We challenge the transfer which is made in violation of the existing policy of the government. Within 7 months of the earlier transfer, he has again been transferred even though policy mandates it. No transfer within 2 years in the same posting.
Page 28.
Status quo has been granted, he is still
Says your representation can be disposed of.
Within 30
till
days.
then, lordship, Doctor,
We'll give you protection.
yes,
till
protection.
disposal.
Yes.
Is enjoying protection anyway.
Yes, yes. And in the midst of this election schedule, probably they will also be not because he is performing his election duties right now.
We'll direct the disposal within 1 month.
1 month. 1 month from, not sure, can it be 2 months because election duties are probably,
And it would be over from today.
yes,
Speedy
June,
disposal.
first week of June, probably the results
Oh.
will, yes,
Or 45 days.
45 days.
Third and account. Right. Galaxy, which order?
At page, not sure,
22,
22,
madam.
22.
The notification dated 12th of March. 24, I think. Several officers were transferred. During the name of the person is found as selected for 41.
Page 24.
He was transferred from along that block Yungbra Development Block. Pensioner is working as an assistant executive engineer under the PNR. The where the transfer the pensioner is calculated on the ground that on 17/7/2023 he was transferred and posted as assistant executive engineer in one of that of Nagaon and purported under the CI guideline. Pensioner that is
Lordship, may I
very
interrupt?
interesting.
They do not refer to the ECI guidelines. They just say it's in public interest. If your Lordship peruses
But
the
ECI guidelines are not relevant here. The office memorandum at page
Submit
submit.
that
Yeah.
without taking into consideration. Again, without taking into consideration the policy decision of the state. Very stated that no officer shall be transferred out in the district within 3 years.
within 2 years. Yes, 3 years, Lordship, 3 years.
3 years without approval of the chief minister of the state has been allowed. So, the Senate council that the best of the knowledge. No such approval was obtained. And within within how many 9 months?
Within 7 months of the earlier
7
transfer.
months of the earlier transfer. Transfer of here. Purportedly in public. Being agreed, he has been further represented. Principal Secretary, PNRB Department. Which he could be. He said transfer order has remained pending. Sorry, the representation has remained pending. Being agreed means support by time. Notice, no, but not support by board by permitting. Directed status. Stated for. However, considering the fact that it is stated representation pending. They need to check the direction. The submission of the learner considering the fact that in spite of the respondent the way support considered state directing the principal secretary PNRD to expeditiously the representation of the party by the examine his prayer for reconsideration of transfer. Such order passed by copy there shall be served. The above directive carried out in the 45 days of 35 with the above observation binding order is passed by the DNR. The representative. Right. The status quo. Yeah,
Your Lordship, we have received the instruction to parallelize comments. We would have to fight the affidavit.
want to file affidavit. Mr. D. Bora, Learned Council, Learned Council, Governor. It's like instruction. Like that. But I don't think that. It's not a but that the interim order extended. And be listed again after 3 weeks,
2 weeks, Your Lordship.
2 weeks.
Yeah.
Be listed again on 20
Yeah.
May. Till the next date fixed, interim order passed, it will continue.
Yes. The matter released to revision, same, my lord. This is the Kabat matter, my lord. I am praying for a similar order at page 51, my lord.
My lord, this order of your, of which my lord has been paid, my lord, fingerprint has paid. Yesterday, my lord, there was a revision petition we had filed, review petition, where my lord has issued notice. My lord, this matter, the judgment has been modified in Kalicharan, my lord, 2199/2024. This lordship, this court's order. 2199/2024. Where the JCC meeting has been incorporated.
Where is the order?
Order is, my lord, I have just sent the order. Paragraph 6.
Yes, are you familiar with the
I have not seen, my lord.
haven't? You take some time to call it. Call the matter, let me take it. Go through it.
At 2 p.m. in this paper.
Not 2 PM, just now. Go. Now you want it at 2 PM.
No problem, after some time, man.
Yes. Yes.
My lord, case list to non-payment of pensionary benefit, my lord. Readability spending, your lordship has already been issued notice, my lord. May I place that order, my lord? It is read.
Third general account. Okay. You are praying for release of pension.
Pension, my lord, old pension. 1969.
For release of pension after the same order.
Same order, my lord. Name is different.
We have not issued notice. Have we issued notice?
No, not notice, my lord. I'm sorry. RTPL is pending, yes, ma'am.
All right, similar order. Then let the, both the matters be listed together. This writ petition and the other.
No other, my lord, yes, yes, yes.
Both are similar matters.
Similar matters, yes. ma'am.
Sir,
Oh, about the same. yes.
This writ petition be listed along with 180. Yes.
Hello, like.
Proceed for timing after 5 minutes.
May please, your lordship. Lordship, matter is pertaining to non-payment of regular pension, lordship. Lordship, initially in the year 1994, lordship, the petitioner was appointed as stability teacher, lordship. Thereafter, he was deputed to undergo the junior basic training, lordship. And after passing the junior basic training, lordship, he was allowed to do the regular scale of pay, lordship. Lordship, the petitioner's case is similarly covered by the Purnima Hore judgment case, lordship. And lordship, your lordship has already disposed one.
Yes, Mr. Sharma, you have gone through it.
Lawsuit, I have just run through the petition lawsuit. If the nature of the penalty of stability teacher, in that case, it covers by.
You should tell us. We'll take it up at 2 p.m. You go through it and tell us.
Lordship, your lordship has already disposed.
I know, let him go through it. 2 p.m.
Lordship.
today. Please go through and tell us. Yeah, similar order.
Item 43, 44 will be same, my lord.
Where is that order? We'll need that.
Yes.
Give us the copy. Where is the council for APTCL?
I appeal for APGCL. Oh, yes, he is the main counsel, ma'am. So, Mr. Nadia. APGCL, employees are APGCL, ma'am. All three employees from APGCL, ma'am.
No, Mr. Sharma was appearing. Where is
He is for the APGCL, ma'am.
APT,
He is APGCL, ma'am.
DCL?
Yes, ma'am. His name may be shown, ma'am, because he is here, ma'am.
Lordship, Mr. Dina appears for
APGCL as
standing counsel, Lordship.
And Mr. Kotopur? Power. APT. See, it also DFT. You have for 3. That is. Oh, sorry. NRA. That.
Lordship, maybe HR does.
One and two.
Is item number 9. Lordship.
Who is there?
Lordship, item number 9. 1, 2, 5, and 6 in
1, 5, and 6.
in item number.
Mr.
Yeah.
HR Das.
Lordship.
You are appearing for 1, 5, and 6.
Yes, your lordship, in item number 9.
5 and 6. Then, who is appearing for 3? Mr. Kot. And 5.
Yeah.
4, Mr. Sharma. is there. 4. Okay, 43 and 44 same, ma'am. Same respondents, ma'am. Interview.
Lordship, on last occasion asked for further documents, Lordship, to show that uh, whether the petition number 1 is the wife and 2 is the doctor. Lordship. As of now, Lordship, further documents is, there is no further document.
How will they verify?
Only that, Lordship,
You want the director,
no.
the authority to verify your claim.
uh,
How will they verify?
so departmental office, they can.
How? On what basis? But they can only verify the procedure of law.
No.
Procedure of law says that's valid. In your sub,
Lordship.
by some authority. Or to the court.
So far as Lordship, petition number 2, Lordship, birth certificate is there. So far as petition number 2, Lordship, birth certificate is there. And
That-
petitioner number 1, only Lordship, voter ID card and Aadhaar card. Lordship.
Huh?
Regarding petitioner number 1, only voter ID card and Aadhaar card. Two documents.
Petitioner number 1 is for second wife.
Second wife.
Petitioner 1 is either way not there. Benefits are not available.
Lordship. But petitioner number 2,
Whether the other is the same person or not. Is there any dispute? Will dispute again.
there is a private respondent, Lordship. If notice goes, then only I can think.
Your Lordship, it's a purely civil dispute, this whole matter, because the private respondent is getting that family pension. And the petitioner, the second wife, is claiming the family, portion of the particular family pension. Now, whether that.
What the difficulty I foresee, unless respondents have an agreed.
No.
Yes,
Yes, if
petitioner number the daughter. Unless there is an agreement.
No.
The same question will come if they go out.
My lord.
So the better thing to put the
For that, he has to come, Lordship. Respondent number 7, if he come, then only he will be able to see whether he agrees or not. On Lordship, then at this stage, Lordship, I may be then allowed to withdraw, Lordship. I file with liberty, Lordship, because he applied for NOK also as per instruction, Lord.
See, we cannot issue an effective order to respondent.
My lord.
Even if we say that all parties that go for a hearing and if he refuses, except petitioner 1 and wife and second wife and daughter. How will you decide? You're back to court.
That is factual aspect, Lordship. That is the authority can.
Subject to an agreement by respondent 7 and to agree. Yes, he is the second wife and
Then my humble submission is, Lordship, then notice may be issued, and if respondent number 7 comes,
no,
and-
he don't want to keep it on his.
No.
Unless you are sure that not going to take. What you find is a which you determine right time. At least the right of the
second,
second the daughter.
no.
Birth certificate is issued by the authority on the basis of medical by
Lost. That was issued in the year, Lordship, 2012 itself.
what material.
Because the birth was can take place on, Lordship, in the hospital.
Yes, so that the father said,
My lord.
Anil Uragma is the father, but nothing. You must have just the name.
Yes.
Father's name.
Village is also same law.
It may be said there are more than one only Uragma in the same. Your name by some potent evidence. Their statement Right away.
Then lordship I may be allowed to withdraw lord, with liberty lord. Because
Heard that petitioner is sick, uh,
lordship.
prayer would be in the top. Or it, the area of
Deeply obliged. Very briefly. My lord, the steps was already taken on yesterday, my lord, on private respondent number 6.
Oh, why did you not take steps?
My lord, this
You are
was
the
actually
legal-
represented by under the department, so inadvertently left out, my lord. I have taken
It
already.
is submitted by the legal aid counsel, Mr. B. Porwal, that steps have been taken yesterday.
Yes, my lord. By registrar.
Registry to verify and make necessary enrollment. It's the last 2 weeks.
Always.
My lord, very good, my lord.
Hmm?
My lord, very good, bringing in the record, PPO.
You have filed.
My lord, pension has been granted now,
Pension granted,
regularly received.
submitted by the.
But my lord, there is another, lordship may kindly peruse the last order regarding the leave encashment amount that was not received. I have also applied for bank statement. That was received. It was not reflected that any amount has been credited to my account. And regarding that, they have not filed their affidavit as per earlier order dated 22/4.
Your prayer is for release of arrear as well as current family pension,
My,
along with other admissible retirement benefits.
my
So pension has been released.
pension has been released.
Now
At
what-
first, they have not released. After filing this petition, they released provisional pension. And thereafter, they released
You have
final
received pension. You have
My
received
lord.
pension.
today, as on today, I have received pension.
Very nice. Now, what else do you want?
Leave encashment benefits, my lord.
Leave encashment. Why is it not been released?
I repeat, my lord, that order, my lord, that is issued on 10/6/2019, an amount of rupees 1,03,410 rupees. That was, my lord, sanctioned in 2019. And the petitioner in his reply also stated that he has received an amount of rupees 6,99,000. Whether that amount is included or not, my lord. My
Where
lord,
is that affidavit?
my lord, in our, my lord,
As per last order, they
my
have
lord, that
not filed
affidavit we have not
affidavit.
yet filed, my lord, that particular document, my lord. We have received, my lord, day before yesterday, my lord, that particular document, my lord.
Your leave encashment.
That document, I have already enclosed my reply, my
That leave encashment of 1,03,410
my
has been released.
I have bank statement for the year
You don't
19.
know your bank statement. You got to the last order.
Yes, my lord, that amount I have not received.
They say they have released it. You have not received.
Not received.
My lord, so I have asked, my lord, that regarding the proof of that particular document that he has received the amount, my lord. That particular document, my lord,
And my lord, Treasury officer
Submitted
also
by
party.
the learned counsel for the petitioner that the final pension order has been released by way of by issuance of the PPO stock. However, the claim of the respondents that an amount of rupees 103410 stated to be the amount towards leave encashment, although claimed to have been released by the respondent, has not been received by the petition. Mr. J. Chutia, learned counsel appearing for the Karbi Anglong Autonomous Council, submits that he will call for the instructions from the department to show as to when the amount removed has been released. Accordingly, get the matter be listed after getting 20.
A treasury officer also party here as per number 10.
What is treasury officer got?
He can ascertain whether that amount released or
That they can enter
my lord. And my lord, my pair is along with interest as per revisor.
or with
Okay.
Voluntary for finance. Treasury officer to verify whether the amount has been leave encashment. Whether it was less than 21, then it was as per the last. And Mr. Big Four.
May I please, your lordship? Matter relating to non-payment pending arrears liability. 28/1/1997 to 10/7/2000. The last was decided by the Honorable Court of Appeal.
I've not heard you. Little louder.
The last occasion, lordship, in last order, lordship,
Yes.
2017-2023, lordship, was decided by the Honorable Court for release the pending arrears in pair number 12, lordship. But till date, lordship, I have not received.
Yes, but
I have received the detailed instruction. Lordship may accommodate me for some time to file an affidavit.
not an account. Are for release an account. It's for release type. Again. 29. By the next date fixed, the respondent will also apprise the court as to what steps, as to whether steps as directed, as to whether steps for releasing area salary, the petitioner for the period 28/1/1997 10/07/2000 has been undertaken after deducting the amount paid on account of subsistence allowance, as directed by this court earlier, ID order dated 27.
From the instruction, my lord, it appears, my lord, that the department has negated the claim, my lord. Anyway, I will bring it on record, my lord. And so, like.
Wait, please, your lordship. Here I am appearing on behalf of Mr. K. Gogoi, lordship. Lordship, can this matter be taken up on 9th, lordship? Today he has some difficulty.
On?
9th, lordship. On a hearing day, lordship.
Something auspicious or not?
Lordship,
Yes, Mr. Nair.
or any other day in the next week, lordship.
At joint request, or at the request of studying council and higher education, that is heard. taken up again. 16.
My lord, 14th then, my
Huh?
16th and 17th, I have some difficulty, my lord. 14th, my lord.
14.
My lord.
We have difficult.
My lord, on next week then,
Docket is absolutely.
my lord, next week then, there are
Then it goes to 28.
28.
28.
Obliged, Lordship.
28. 20. Or we can have it on a miscellaneous day.
My lord, my lord, my lord,
20, have it on 22nd.
my lord, my lord. My lord, yeah, 22nd. Deeply obliged.
Highly obliged.
Well, in this case, well, after my lord, 20 years of service, my lord. 1 month thereafter, my lord, thereafter, my lord, regulation of the job of my husband, my lord, who was the headmaster, expired, my lord, paid for petitioner, paid for family pension, my lord. This case is, my lord, on exceptional circumstances, it can be considered, my lord. There is a provision I have, my lord, served one judgment, my lord. In this case, my lord,
Yes.
I
They
think-
have, the counter affidavit has been filed.
Fine.
You are you filing any reply?
yes, my lord, we have also filed reply, my lord.
Reply.
Yes, my lord. In terms of this, my lord, judgment, my lord, the governor has the power, my lord, for consideration of this, my lord, distress of the petitioner, my lord. Petitioner, my lord, service was regular, my lord, on 16/5, husband service was regular 16/5/2013, annexus C, my lord.
What is the stand of the respondent?
My lord, it is provincialized, my lord. The service of the husband was provincialized, my lord. On my lord, 16/5/2023. The date is important, my lord. And the effect was given, my lord, 1/1/2013. And the husband of the petitioner died on 24/2/2013. Only 1 month service, 1 month, certain days the husband of the petitioner, as part of our lord, provincialization order, my lord. He served, my lord. But before giving effect, he died, my lord. And as part of my lord pension rule, to get the family pension, 7 years as per rule 142, 7 years continuous service is required. As the husband of the petitioner only rendered after provincialization, less than 2 years, so my lord, the family pension was not granted.
This provision, my lord, this rule, my lord, 233, my lord, onwards.
Which provision?
Rule 142. নাই তোমাৰ হেৰি নাই নহয় এতিয়া এইটোতো তোমাৰ 17 পিছত যদি হ'লহেঁতেন তেতিয়া আহিলেহেঁতেন
এইটো exceptional,
সেইটোতো গভৰ্ণৰ পাৱাৰ
governor power.
সেইটোতো এক্সেপশ্যনত থাকে সেইটো এক্সেপশ্যনত পৰে নপৰে
Yes, then
My lord, the case of the petitioner is also that, my lord, new pension schemes came into effect, my lord, to the employees who appointed after 2005, my lord. Petitioner has annexed that particular document also, which is at page 37 of the repetition.
Yes.
In that paragraph, my lord, paragraph 5(2), my lord, page 37. Page 36 is the office memorandum, my lord. That is the NPS scheme is applicable to the persons whose service were appointed on or after 1/3/2005.
I think this It came to be amended.
My lord, yes, my lord, that has been amended, my lord. 142A is inserted, my lord.
What is 140?
My lord, that is the gazette notification, my lord. And it affects from 2017, my lord.
So my prayer is now, my lord, this exceptional circumstances will come. My lord. Power of the government. 233, 234 and 235, my lord.
What exceptional?
Yes, kindly peruse your lordship. That judgment is also followed this rule, my lord. Removal of doubt, 233.
Removal of.
Yes, my lord. 233. If any doubt, my lord, arises as to the interpretation of any of these rules or about the applicability of any of these rules in case of any person governed by the rules in the Assam Pension Manual, second edition, immediately before commencement of these rules, the matter shall be referred to the state government in the finance department who reserve to themselves the right of changing the rules and interpreting their meaning and whose decision thereon shall be final. 234, special provision. In any case in which a pension is not admissible under any specific provision of any of these rules, the governor may sanction the grant of pension in exceptional circumstances if the grant is not inconsistent with the general spirit of the rules. 235, where the governor of Assam is satisfied that the operation of any of these rules causes undue hardship in any particular case, he may be dispensed with or relax the requirements of that rule to such extent and subject to such condition as he may consider necessary for dealing with the case in a just and equitable manner, provided that the case shall not be dealt with a manner less favorable than the provided in these rules. The judgment, my lord, fully covered this case, my lord. Earlier, this Purnima Burman, who filed this case in the year 2013, my lord. Also, there was lack of, my lord, this stipulated period of service, my lord. 4 years, 4 months, 5 months onwards, my lord. Thereafter, as it was less than the said stipulated period, our service was directed to be considered as per the these rules. And accordingly, this Purnima Burman is getting her family pension nowadays.
Where is that?
Family pension order I have not along with me, but this judgment, followed by this judgment, governor considers, because here also petitioner continues, my husband continues up to 20 years of service, my lord. I have annexed even the, my lord, appointment letter also, my lord.
You're referring to page 45.
Lordship?
Which judgment? Page 45.
No, my lord, I have given extra. Yes. That judgment was not earlier, my lord.
Purnima Burman.
Yes, my lord.
You will just come back.
Yeah.
The order. It does appear to be a complete order.
WPC, W,
636.
yes, my lord. Oblique 13.
Yes.
My lord, one order which he has annexed. Proceeding kindly see, my lord, rule, if my lord may be pleased, because if my lord is taking up, my lord, rule 140, at the pension rules, my lord.
The order is
Yes. There, my lord, this honorable court was pleased, my lord, to dispose of that particular writ petition, relegating, my lord, the petitioner to, my lord, make a representation
you're
before.
referring to the order of 845.
Yes, my lord. Page 45. If my lord may be pleased to come to page 46, my lord, paragraph number 8, 9 onwards, my lord. In view of the above, learned counsel for the respondent submits that if the case of the petitioner is covered under the said scheme, the authority will do the needful for release of the pensionary benefit. Accordingly, the present petition is disposed of, directing the respondent authorities to expedite the process and finalize the same if found eligible under the aforesaid OM dated 14/6/2016, which has also been relied here in my lord by the petitioner, so that the petitioner can enjoy the provisional pension as provided under so and so. The aforesaid exercise within a period of 3 months. Now here, my lord, lordship may kindly come to page 37 of the writ petition. That is a part of the scheme, my lord, that office memorandum issued by the, my lord, Pension and Public Defence Department. It starts at, my lord, page 36. Relevant portion, lordship will find it, my lord. My lord, page 37, my lord, clause 5. Death in service not attributable to government duty. There, my lord, will kindly come to clause 2. Family pension computed in terms of rule 140 and 143 of Assam Services Pension Rule 1969. Now, rule 140, my lord, in order to come within the ambit of rule 140, the person himself at the first instance will have to become eligible for grant of pension. And in 143, my lord, even if the person, 142, my lord, I'm sorry, 142, even if the person is not entitled, then, my lord, he may be brought within the ambit of rule 142 if he satisfies, my lord, that he had rendered minimum 7 years of continuous service. If for a moment lordship takes up rule 140. May I read it, my lord? Except as otherwise provided in rule 142, a family pension not exceeding the rate mentioned in rule 141 will be admissible in case of death of an officer while in service or after retirement on or after 1st January 1964, if at the time of death the retired officer who was in receipt of a compensation invalid, retiring or superannuation pension. In case of death while in service, the government servant should have completed a minimum of 1 year of service. So therefore, my lord, in terms of rule 140, first of all, my lord, the government servant concerned will have to become entitled by, my lord, serving for at least 1 year, continuous service.
How many service, how many months?
2 months, my lord.
2 months.
2
So-
months thereafter.
So, my lord, at the first instance, I am the officer. I come within the ambit of, my lord, rule 140. Then, my lord, the benefit will, my lord, pensionary benefit, my lord, family pension will be applicable. Now, if my lord comes to rule 142, because this is the distinction between rule 140 and 142. 142, my lord, at the first instance, my lord, notwithstanding the provisions of rule 140 and 141 above, if a government servant after rendering minimum of 7 years continuous service dies in service, the family of such government servant may be granted pension of so and so conditions mentioned. So therefore, my lord, in rule 140, since a person already becomes entitled for pension,
140, 140, you're entitled to it 1 year of
1 year service, and if he becomes entitled for pension, the authorities will have to decide if he becomes entitled.
not this entitlement, so it is a certain
Yes, service rendered,
1 year.
yes, 1 year continuous service,
Regulation.
on continuous service or superannuation pension. Now, whether he is in receipt of superannuation pension, because 140 comes into effect,
The difference between 140 and 140.
because, my lord, 140 and 142, a person is in service, he, my lord, he continues for 1 year of continuous service. he becomes entitled. Then he dies. Then, my lord, the family pension issue comes up. Then, my lord, 140 is affected. Now, my lord, if 142, he is, my lord, doing his service, he is not entitled for pension, but he dies. And then, my lord, the family pension, my lord, creeps in. Then, my lord, 7 years. Therefore, my lord, in 140, the period of service is, my qualifying service is 1 year, and in 142, the period of qualifying service is 7 years. So the burden is heavy under 142.
We're saying
My lord.
140 is where government service is not entitled.
Not entitled to family pension, my lord, because this is the language. It doesn't say about any family pension. Kindly see the language of 140 and 142. 142, nowhere it is stated, my lord. Notwithstanding the provisions, if a government servant, after rendering minimum 7 years of continuous service, dies while in service, the family of such government servant may be granted a pension. Meaning thereby, my lord, that at the first instance, the government servant himself was not entitled to pension. But since he has completed, my lord, 7 years of continuous service, so therefore, my lord, the family becomes entitled for seeking family pension. But in 140, the language is clear. A family pension not exceeding a rate in case of death while in service, if at the time of death, the retired officer was in receipt of compensation, invalid, retiring, or superannuation pay. That means he has already qualified. The deceased employee has already qualified for being granted with pension.
It has two parts. One
My
is the death in service.
Yes.
So if it is the death in service,
In case of death while in service, the government servant should have completed a minimum period of 1 year of service.
One.
Then, yes, then the note kindly lodge.
can be death post retirement.
No, the note will kindly say, Lordship will kindly see note 1. The term 1 year of service mentioned in the above rule does not include broken periods of service. The service for this purpose should be continuous.
There is 141.
141, my lord, is the, my lord, computation of the quantum of pension, how it is to be computed. The formula is deduced,
Now, as far as is concerned,
my lord.
you would ordinarily have come under 140.
He would ordinarily would have come under 140, but because since, my lord, he has not completed, my lord, 1 year of continuous.
How many years otherwise is
20, more than 20 years.
20 years?
Yes.
When was it? And post regularization, post provincialization.
2013.
1 month 23 days.
1 month post
1 month
regularization.
Provincialization, my
So
lord.
after
The school was provincialized, my lord, on, my lord, by notification dated 16/5/2023.
with effect from
And
1.
effect from 1/1/2023. The husband of the petitioner
13.
died on 24/02/2023.
Give us the date again. He was
Notification, my lord,
provincialization order.
provincial order and annexer C is an
What is the date?
16/5/2023.
13.
13.
13, my lord. 16/5/2013.
35,013.
30. With effect from 1.
The effect from 1/1/2023.
13.
13. The husband of the petitioner died on 24/2/2013. Here are the date. One month, 23 days service.
I is 33rd. Right?
My lord, there is a private school, my lord. There is a
That-
managing
that-
committee.
That service has, will not be counted in view of Rule 31. Lord, Rule 31, my lord. This is the basic rule.
Recognized school, my lord. Government.
Conditions
The service the government with the boss.
substantive and permanent service must be paid by the government.
Correct.
Third condition.
He satisfies first, second, and third.
Oh, my lord.
Satisfies
Firstly, the services must be under the government. Now they say, my lord,
after provincialization.
yeah, after provincialization, so the services under the government, my lord, after provincialization, he will be, my lord, he comes within the fold of government service. Then he qualify. He serve only for, yeah,
Like,
yes.
he satisfies to 30. After
After provincialization, in my respectful submission, my lord, subject to lordship's correction, my lord. My lord, here, firstly, the service must be under the government. So he comes under the government service once the school is provincialized.
Right.
Now, after once the school is provincialized, he comes within the fold of a government servant. There, he continued to serve for less than 2 months.
let us stick
Yes.
we are going 140. 31 figure. He must be under the government. That by must be substantive and permanent.
Post provincialization.
Salary must be
Post provincialization. So all the three.
required.
Yeah.
That's right. After
Yes, absolutely. So therefore,
he had 140.
140, and then whether my lord the past services. Now, if he bring
142 according to 11 months,
less than 2 months, they say, my lord,
10
less
months,
than 2 months. Yes,
2 months,
yes,
he falls short by 10.
yes. He falls short by 10 months.
Direct take that letter earlier.
So therefore, he will have to plead out that case. It is not his case here. My lord, that the past services has to be counted and so on and so forth. We will have to be given.
Otherwise, he not get a benefit.
Definitely, my lord, we will have to go by the rules, my lord. Then, my lord, whether the past services can be counted in this nature, my lord, then, my lord, we will have to be given an opportunity, my lord.
Unless there is a dispute that he never rendered,
So, my lord,
he has rendered service.
rendered services, my lord, at 2 stages. So therefore, if lordship, my lord, tries to give a benefit, mold a relief, my lord, that it will amount to, my lord, counting his past services. And if that be the case, if that be the view of this honorable court, then lordship will kindly, my lord, allow the respondents to file affidavits, my lord. Because otherwise, my lord, otherwise on law, legally also he is not, my lord, entitled. Counting of past services. In all cases of this nature, my lord, all the employees come. Not substantive, my lord.
Rule 67 is there, my lord. Exception, my lord. Upon such condition as he may think fit in such case, impose the governor may condone a deficiency not exceeding
That is
12
the
months.
discretionary power.
Yes.
That is the discretionary power. He cannot seek a mandamus from this honorable court, compelling the authorities that you have to do it. That is the discretionary power.
But it breaks.
Yes, that is the discretionary power. Therefore, my lord, he has relied on this decision. Now he is, my lord, taking a flip-flop. At page 45. If he is satisfied, my lord, with this kind of an order, my lord, lordship may dispose of this writ application, delegating him to the authorities, make a fresh representation, my lord.
Yes, my lord.
That's it.
Fresh application, my lord.
Yeah.
Yes, my lord.
My lord, it will be, my lord, to the administrative authority, my lord, it will be to, my lord, the respondent number 2, Director of Elementary Education, Assam, Kahilipara. Because he is the, my lord, controlling authority.
Oh, really, my lord.
Appointment letter from the. Photo report. Already report, appointment also.
Salary release. Rule 67, ma'am.
Not acceptable.
My lord, to the respondent number 2, my lord, Director of Elementary Education.
Direct- direct- I rest- uh, 7.
if found entitled, my lord, because this is a discretionary power, my lord. Like, if at some point of my lord's order, my lord, it mentions.
Necessary discretionary power court filter. If the court finds, if the government finds that they're not entitled, but the discretion is there.
My lord, my respectful submission is that, my lord, the tenor of my lord order is, my lord, that the authorities will hang as if it is a mandamus, my lord, kindly, my lord, somewhere.
Authority, the authority takes it. So, that's all. It is not verifying
Yes.
that
Yes,
that
government, yes. I'm obliged. I'm
Okay,
Three, five, and seven.
appeal.
Well, I appear only for the treasury officer, respondent number 6. The finance is not implicated as a party. I'm obliged.
The petitioner of the IA is the legally married wife of respondent number 5. And they have some differences, but they also have a mentally challenged son who's 26 years old, and she has to maintain him. The family court
File an IA.
will file the IA for impleading her as the nominee, the legally married wife, the petitioner of the IA. As the nominee of respondent number 5.
My lord, we have not been served a copy, my lord. Today only I could learn that such an IA has been presented.
A copy may be served to us.
We shall do
My
that.
lord, the matter relates to pension, my lord, regular pension of the petitioner, my lord. My lord, the consequences will automatically follow, my lord, that if somebody is nominee or not nominee, my lord, it will follow in accordance with the rule, my lord.
Because there is a
Right.
order from the learned family court giving her maintenance. Her and her son obviously sharing the maintenance, and
obviously,
she's
my lord,
not getting the payment regularly.
My lord, how
So,
can I make the
impleading her as
payment, my
the-
lord, as I am not getting the pension, my lord? That's the problem.
Impleading her as the nominee is paramount. Anyways, under rule 136, the wife, the legally married wife, should have been the nominee. And I'll serve the copies. I'll verify with my clerk and serve the copies within the.
But the like the
My lord, I am the writ petitioner, my lord.
river,
My lord, the regular pension, my lord. Provisional I am getting, but the regular not getting because of, my lord, some interdepartmental communications are going on since long. Now, my lord, suddenly this my lord,
you're not staying with your wife.
no.
There are differences,
You're not staying.
but there's
My-
they are not divorced or anything. That if he had filed a divorce,
No, my lord, my respected friend has said that impleadment is a nominee. First of all, my lord, he is required to implead as a respondent in the writ petition, my lord.
that's the first prayer.
First prayer, my lord, and
That is
second,
the first
and the
prayer.
second, my lord, the consequences of that, whether
When
the
you're not, so we can.
my
Mandamus, if
implead them,
No.
my lord. My lord.
We shall do the due process. It's I mean it's an IA filed because this case is going on, and she is like
No, first,
Yes.
let us find out why the pension is not, why.
My lord, the pension has not been released. The Department of Public Health Engineering Department did not send some vital documents to the Accountant General Office. That was the last instruction they have received, my lord.
Now, what has happened now?
Now, what is the present?
Please tell us.
We have a fresh set of
Who is it?
lot of final papers have been sent to the AG.
My-
Earlier provisional was granted. There's some issue in the family court lordship, but in the in this writ proceeding lordship that will not be relevant. So now final papers have been sent.
Final paper.
Yes.
My lord.
Accountant.
Accountant general.
My lord, may I pray, my lord, that whatever the requirement is, my lord, regarding for getting my pension between the interdepartmental communications, my lord, that they can conclude within a month or two, my lord, and if, Lord, I am entitled, then they will provide me the pension, my lord. In that line, my lordship can dispose of the petition, my lord. And regarding maintenance and the family court's order, my lord, I am duty bound to follow the court's order. My lord, until and unless I get my,
There is
my,
maintenance order as well as the divorce decree was also cancelled. It was the petitioner and it was not granted. Hence, our prayer is very limited, madam. We just want to be the nominee. The enhancement is pending, but the maintenance petition was disposed way back in 2002. And our prayer is very limited. We just want to be the nominee.
Not direct the people nominee, but the family court direct that you are trying
my lord. And my
Yes,
lord,
but
if I am,
for nomination,
to
for nomination,
my lord,
but if we see the rules, we are also entitled to be the nominee. And hence a writ may be issued on in that regard in our favor.
where is the
136, page number 147, 2. 130.
every
The rule 136, number 2.
family is family court, the
Yes,
person.
these are the persons. And number 2, an officer shall, as soon as he is confirmed or completed 5 years qualifying service, make a nomination confirming on one or more persons the right to receive any gratuity that may be sanctioned under sub-rules 2 and 4 of Rule 135, and may and any gratuity which, having been admissible to him under sub-rule 1 of that rule and Rule 111, has not been paid to him before death. So, I mean, there are a lot of things, but there is a provision for nomination. We just want to avail that nomination provision since we are already suffering a lot.
Lord, for that, my learned friend can make a presentation before the authority concerned, my lord, in a writ. My petition, my lord,
We
the,
have done representations
lord.
to them, but I mean, they have sent us to the court indirectly.
Your IA. Let the let
pension.
once they complete the path, right?
Highly obliged. That's all we say.
Yeah. Yeah. Seven.
Right.
You know, right. Process property by by the administrative. The IA. Is by yeah. By
Whether that is mandatory or not, my lord, that my lordship can examine over. Why?
Or there's both- yeah, seven.
You obliged.
Obliged.
Lordship, I have received an instruction just now and I have mailed it, your lordship, mail of the app.
Just now,
Yes, lordship.
what to pick?
আপনি ডিসেম্বর করতে পারছেন।
What,
Your lordship.
what does the instruction
Oh.
say?
May I read it, your lordship? Same one.
You read it and tell us.
Yes, your lordship. In inviting a reference to the subject, I have the honor to state that an amount of rupees so and so only is required for sanctioned area salary in respect of Monica Boro, grade 4 employed with so and so school under Borpata district in connection with so and so WPC in context of non-dual certificate submitted by the principal, duly countersigned by the Treasury Office, Treasury along with required area particulars and also enclosed herewith. I would therefore request the government may be pleased to accord necessary sanctions of an amount of so and so, your lordship. Therefore, address the school with pictures and Borpata with that in expenditure will depend on the head of school. This is the only instructions I have received, your lordship. During the financial year. Already, sir. Delay. Ah. Yeah, Allah Baba, thank you, sir. Yes, sir. Lordship.
Do you have a copy?
No, I just, I think the WhatsApp.
Did you submit?
Ah.
For various other respect of the has been forwarded.
Secretary.
Or 3-5. 3-5 today.
Yes, sir. Lordship.
Just gone
Yes. I have just
from 3-5
2 minutes ago, Your Lordship.
That view of the matter. That- Yeah. I- it is for the- I- Yes, there are
H, Your Lordship.
eight. There are-
Miss Peter. Kindly peruse the earlier order of this honorable court, my lord. No affidavit has been filed, my lord, by the department, by the respondent, my lord.
Here,
Matter pertains to, my lord, non-payment of retirement benefit, my lord. And it is clearly covered by Sanjita Roy, my lord. And another prayer, my lord, the respondent already recovered, my lord, some amount from the leave encashment after retirement. I pray, my lord, to release of that recovered amount also from the irrigation department, executive engineer.
and the pension to, yeah, no,
Yeah.
who's for the irrigation? What do you say?
For instruction matter, first is going to resubmit a proposal of the petitioner matter. But at present, the status book is with the AG.
AG? Yeah.
Yes, matter. For instruction matter that.
AG, my lord, only my lord, paid the terminal gratuity, my lord, and it is 27. On the reason that the petitioner has not completed 20 years of service
Yes.
after deduction of 6 years.
Actually, my lord,
My lord, the already pension proposal has been sent to the AG matter earlier.
Okay.
Now, my waiting the area amount, we have also withdrawn amount, going to submit the pension proposal matter.
18.
Here, actually, I have received instruction, my lord. This is the case where he is entitled because Sanjita case, Roy clearly said that 20, whatever 6 years deduction is to be, not to be done. That is why 20 years service is required. I think he has completed 20 years service.
25
What have we
years.
did it, then that is also on a part wrong. We have admitted because Sanjita case should have allocated this later terminal
18.
later. No, no,
18.
terminal later get it.
Terminal paid on, my lord, 17/1/2022.
17 on
After-
22, that means he is entitled. Pension will be entitled. Here only another aspect is a lordship intervention I put one addition. Department concern Miller. Lordship did it. Good enough. Angini divi, completely. Here made us confusion. Why? Because your lordship last paragraph. That is a really, we also surprised why this letter is given, my lord. AG also. That is letter last page, your lordship will see. Lordship got it? Here they are saying, my lord, this Commissioner Secretary Governor of some pension of public branches, the person who were engaged 1490 before 1993 only, Sanjita Roy case will be applicable. But it is not so. Because Sanjita Roy case doesn't say anywhere that it is if they're engaged before 1493 or that there is nowhere that is mentioned. Only that is 20 years. But this later is making us very awkward position, my lord. This is why in entire general cases it will be affected. This by this. That's why I am putting to an observation. Yes, that is why we are also saying, because this letter is contrary to, but they are writing to us, this department is writing because as your lordship are, as we are monitoring authority only, we have to obey rules, regulation of instructions from government. Yes, this is the contrary.
With the government, I think it nowadays. Pension and public grievances. This is contrary. Why? Because it is confusing for us. It should not be like that. It doesn't say anything regarding and date of engagement. Only says 20, 6 years might not be deducted.
Yes, Sanchita Rai is, my lord, basically correct. My lord, 20 years, that 6 years is not deducted.
But your letter says were appointed
Prior to that,
there is no direct-
no.
There is no direction. This is a misconceived, my lord.
And
So what are you? Now?
my position.
Yeah.
My position, if it is covered by before 194,
25 years, 1 month, my lord.
no, date of engagement.
Date of engagement, 1/1/1992.
No, then that this letter also not cover up. That is why he'll be entitled. By this letter also.
Are the papers before the pen? How did that now?
No, they think, because I don't know, they think, my last print is saying, I have to verify in that, where the records.
Verify and come back.
Yes, I'll verify, because regarding records, I don't have any. নেপায় বুলি লিখি দিছে না your case, all cases কৰি আছে না verify about the record.
Very nice.
Pension is a party.
Party, my lord. Document number 2. Correct.
They have paper after 29.
Document number
26 or 25 or may not be 20 to 29 minutes. I'll be after this. My personal problem. My lord, like.
Oblige.
I therefore are second better.
Map is okay. So in this case, PPO has been generated, Lordship, and accordingly it was forwarded to the Treasury office. So I have
Close it. Get close it.
till now the money has not been released. Lordship, may close, Lordship.
6 and 7.
Okay, instead of dismiss, Lordship may close the request.
So in this case also PPO has been issued.
But money not reached.
It is only yesterday.
FPPO, no?
Where will that person? I'm for 1, 2, and 4.
I'm for respondent number 3. Respondent number 3,
Three. Yeah. By type vote.
1, 2, and 4. Obliged, Lord.
Regarding non-payment of current and arrears salary, ma'am.
Lordship, we are yet to receive instructions, Your Lordship, in this matter.
May have for a fixed date.
Third.
Obliged.
May pick the response.
So see, we need some more time.
You are trying to sort it out.
We are trying our
Both count. Yep.
obliged.
Brother favorite.
It's very Sharma.
B.
B. Sharma.
My Lordship, it is still under process, Your Lordship. For,
What is still under?
for the reduce of the year salary, Your Lordship. Lordship, a short date may be before event because Lordship, lot of time has gone. Can it be little earlier, Lordship, because he's not getting his leave salary and other things. The sanction order was passed on 15/3, Lordship, and thereafter they've been
Right.
taking time.
22nd.
Much of it.
My lord, item number 26 and 27 are same matter, my lord, and petitioner before your lordship is paying for her area salary from the period of 16/10/2015 to 14.
Part of the series.
Yes, this earlier, this is a part of the series because I have separated this matter from that series because that matter was praying for some of the petitioner paying for current salary. But here the petitioner received the current salary, but the area salary is not paid, my lord.
Yes, for the response.
PTC authority is there, but
PTC, where is PTC? Record. Respect of areas. From which period?
16/10/2015 to 14/7/2022.
16/10/2015. 7. Respect, sir. Very happy. You're appearing for PTC.
Yes, Your Lord.
What to have
Lordship, we are still awaited the instructions.
another council? Please further time. Good. Good. 5th of June,
Yes, madam.
the respondents are permitted to complete their file.
Can it be
It's not.
earlier, can it be posted in earlier date, but 1 month is too long time. In the month of,
29,
yes,
29. May.
much of it.
May I please, Lord? My lord, matter pertaining to non-payment of area salary. My lord, we have received instruction from the petitioner that a order was issued by the Director of Secondary Education, my lord, for release of that area salary, and he has submitted in the Treasury Office, my lord. My lord, matter may be closed.
It's up. That take order.
Yes, sir. Deeply obliged, my lord.
May it please your lordship.
May I please, your lordship? Your lordship, in this matter, your lordship, I am appearing on behalf of Mrs. R.S. Devi. Due to some personal difficulties, your lordship, I pray that 2 weeks' time may be given, your lordship.
My lordship, they have already filed their affidavit.
Yes,
Their-
your lordship.
In their affidavit, they have specifically admitted my claim, my lordship. They're seeking instruction on what occasions, I don't know, my lordship, but I have 2 judgments on penalty. I am seeking disposal, my lordship.
Your lordship, I pray 2 weeks' time may be granted, your lordship.
Similarly situated petitioners who have, my lord, yes,
You have filed your affidavit.
yes, my lordship. They have filed their affidavit.
Where is the apartment?
My lordship of Perus, Para 4. Page 20, my lordship.
Your lordship, we have sent further instructions, your lordship, as regards.
My lordship, may come to page number 24 also.
Really? Tell us.
My lordship, it's with regard to gratuity amount. They have admitted it.
Where? It's fine.
Page number 24, Sulay Hansi, my lordship, it's in a column
Where
manner, my
is
lord.
the affidavit?
It's
Is the affidavit construct?
paragraph number 4, lordship, including the petitioner along with 25 numbers of retired employees, my lordship.
I cannot read the paragraph.
My lordship, sorry, my lordship. That with regard to appointments or statements made in paragraph number 4, 5, and 6 of the writ petition, the answering report.
Read the whole paragraph. But the paragraph. Here,
Yes, my lordship. Para 4, my lordship. Page number 20, my lordship.
Much obliged.
Bring to disposal, my lord.
You're praying for this. Can't pray the point out. Relevant point.
They have admitted along with 25 numbers of petitioners.
Thank you.
My lordship, date may be fixed, my lordship.
29.
Much obliged, your lordship.
My lord, here I am awaiting for up to date instruction, ma'am. Kindly turn one.
I'm for it. I'm for it.
Obliged.
Lordship, may it please you, learned counsel for the other side was director of the instruction. As regards non-payment of DCRG as a regular pension to the petitioner.
This is an old instruction, Your Lordship, in 3/11/2023, Your Lordship. This has not been paid for non-submissions of non-liability and for audit report, Your Lordship, that has not been received.
I think the principal, your lordship. Present principal, my lord.
Why?
That is our case. my Arnanda. Yes, my lord. Miss Arnanda, on behalf of, this one, my lord, SC Biswas. They have filed their affidavit. She will get my lord, because allegation is there. I have retained certain amount of Saraswati Puja. I went on lordship for medical checkup. I'm ready to return that amount, little bit of small amount, your lordship. There is no allegation as such that I have misappropriated that amount, my lord. No department. No, I retain, it was with me, my lord. The present principal, because of his personal enmity, your lordship. SC Biswas used to appear, your lordship. Lordship.
May I please the lordship? I'm appearing for the respondent lordship. We had to file affidavit in opposition lordship. Some clear and legible copies of the annexure are not available lordship. For that, so 1 week time maybe lordship. Lordship, it has not come after typing lordship. We have given the affidavit, but some annexures were not legible. So we have sent back lordship. Why would we on behalf of Mr. H. Gupta lordship?
Yes, K. Chakraborty. K. Chakraborty.
Where the government has no role to play. But here in this case, lordship, committee, management committee has been constituted by the deputy commissioner. That is under challenge. That is lordship page 34. Page 34. There is certain law that in case of private institution.
Right. 23.
My lord,
Which day?
my lord, 4th July 2023. My lord.
Right now?
My lord, what happened, lordship? After constituting this committee, lordship, page 35. This is the, I am the principal of the college, lordship. I have been placed under suspension. And subsequently, lordship, Sucos notice was issued, page 38.
Who was the principal when the committee was reconstituted
My lord, I am the principal, lordship.
in July?
At that time, I was principal.
So this is irrelevant.
My lord.
You started off by saying that DC has reconstituted the committee. DC reconstituted long back. You are a principal, you are not aggrieved. Now you are aggrieved by your suspension.
My lord, one after another, lordship, this illegal committee, lordship.
How is it one after? This is in January 24.
My lord.
That was in July.
My lord, this basic purpose of this constitution. My lord, if you
Chartered Council for the parties issued notice that Mr. P. Soikia for
3 and 4 minutes.
respondents 3 and 4. And Mr. D. Upamanyu for 1 and 2. Is it a part of higher education?
Higher education. Higher.
What has higher education got to do with?
It's a law college, my lord.
Under the bar council.
But otherwise affiliated by
University
Silchar
and
University.
And
bar council.
university.
My lord.
Which university? Silchar.
Silchar University.
Okay. Uh, Notice on all the other respondents by usual course as well as the extra course taken within a period of 2 weeks from the to be listed after the internal.
Some protection lordship is there.
What protection?
In terms of lordship, so for the court,
Examine your suspension order, that's all.
look, no coercive measure may be taken, no coercive measure may be
What
taken.
coercive?
And perhaps he will be terminated, may be terminated in the meantime. Lordship.
No, your termination has to follow, is to be followed pursuant to disciplinary proceeding.
That,
You are apprehending termination.
yes, but that can,
Petitioner apprehends termination pursuant to his suspension. Stop needless to say any such steps that the court has proposed to take shall be only as per the process. And will be listed in court. Yes. Stipended.
Offender teacher, my lord, relying on Purnima Hore's decision.
Paragraph.
In fact, my lord's order is also there, my lord. Lordship may
page
kindly
number
come to
66.
66. Page
And extra
66.
66.
66, my lord.
Same order.
Same order window.
Yes.
Yes, Lord.
Third learning. Page 66.
Lordship, only that is different.
They will look into the dates.
Obliged.
Yeah.
My lord, in this case, my lord, I was supposed to obtain some instruction, my lord. As to, my lord, whether Eastern Frontier Rifles is under the Union of India or not, my lord.
Or state of West Bengal. State of West Bengal. Now you have to take instruction.
My lord, may period for some more time.
Counsel for the petitioner prays for further time. Okay, with instruction. The KK on the appears for
Respondent number 4.
respondent 4. Anyone else? Is taken after 4 weeks.
Obliged.
May I please, your lordship. This matter on the last occasion your lordship heard, this was with regard to the transfer on the ground of safety and security. Just the issue was that I applied for transfer on the safety and security ground under Rule 9. I was transferred from Borpeta school to Kamrup school.
Then he challenged, then it was
Yeah,
back.
then that was that was set aside by the Honorable Court on the ground that Rule 9 have not been followed for the approval. Your Lord, and reconsider the same. So thereafter, the reconsideration was done by them, but they did not issue any order, but gave me an option of selecting 2 places, which I refused. So that is basically the case, your lordship. My humble prayer will be at this stage, rather than keeping it pending, let them take a call on my application, subsequent application following Rule 9. That's it. If I am transferred to a particular place, whichever place is acceptable to me or not, that will be a subsequent.
Pursuant to the order of the High Court.
Yes.
No order was passed.
No, then order was passed, but that was not a transfer order. It's an option given to me. That option was whether I'll go to a Bokel High School, Dibrugarh, or Borthol Dolaigaon High School, Morigaon district. It was not a transfer order as such.
Where is that?
Consent was sought.
Where is
That
that rule?
rule, your lordship, I have annexed that particular, I have quoted that
in paragraph at page 8, paragraph 7. This is the Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act 2020, Section 9. In case of exigency of for maintenance of proper academic atmosphere in a school or for maintaining peace and tranquility or safety and security of a female teacher, here it is a female teacher on safety and security. The Deputy Commissioner of a district, after observing such formalities as may be prescribed, if satisfied that transfer of a teacher is essential for any of the said ground, may refer to the competent authority for transfer. Even from a low PTS school, the competent authority shall immediately consider such proposal of the Deputy Commissioner and recommend to the concerned appointing authority for issue of the transfer. So this part, the competent authority, the Deputy Commissioner has sent, but the competent authority have not issued the transfer order.
Where is the recommendation?
Recommendation is directly uploaded in their website that I have annexed. That is at page, your lordship will find it page 62. This was directly uploaded in the site. The safety and security setting.
Where
So
is
after that, your lordship, the next page, page
Where is the-
63,
Safety and security. Certificate is not here.
not here. That
Some-
has been uploaded in their site because this is a whole process is online. Then they issue the letter to me, the mission director, directing that I should give my preference or consent to join any of the two schools. This consent was not given. So the matter ends there. Then I again made an application for giving my preference, your lordship, and the matter stands there, and I came before this honorable. So my prayer will be that at least let them consider my prayer and pass an order as per Rule 9. That's it, your lordship. If it is convenient for me, then good and well and good. Otherwise, I don't know how to, your lordship, because earlier they have given an order on the basis of my application, your lordship. If they could have accommodated then, what is the problem now? Now they are saying that there are no posts, vacant posts. But earlier also I was not appointed in any vacant post. I was given a transfer to a particular place against a particular person.
So when you first came before the court, pursuant to the transfer order, there was no recommendation.
No, that there was a approval has to be given by the as per Rule 9, your lordship. There are two parts of Rule 9. Lordship will see that the Deputy Commissioner of the observing such formalities as may be prescribed, if satisfied transfer of a teacher is essential for any said ground, may refer to the competent authority for transfer. But this later part was not done. Directly a transfer was issued without the competent authorities competent authorities direct whether I should be transferred or not. Directly a transfer order was issued. On the transfer order, initial transfer order was issued by system. This is at page 37. This is the mission director. Page 37 by the mission director. This was challenged. Then this court by order dated immediately thereafter, 13/2/23, it was
Now,
set aside.
If you come to section 9,
Yes.
the application is to be made to be that the certificate is to be given by the
Deputy Commissioner.
Deputy Commissioner. And it is to be recommended to the competent authority.
Yes.
Who is the
And then recommend.
Who is the competent authority?
The competent authority here is the government.
And who is the appointing authority?
Appointing authority, these all the teachers are director, your lord.
No, because there are three authorities under section 9. One is the DC,
This is only to issue the
right?
safety security
So he has
certificate.
to see that certificate would be forwarded to the competent authority. Competent authority will consider the proposals and recommend to the appointing.
Yes, the appointing authority is I think the director, my lord. Mission director,
Mission director.
Yes.
And
Because this is under the server 6.
so who considered the proposal of the DC?
Here your lordship. At page 49 of the order, your lordship. This High Court's order, this has been reflected.
No, no, no.
So I think this competent.
No, you come to the definition.
Yes.
Definition to C.
This is under section 7.
2C.
2C. Okay. Yes.
The appointing
State level committee.
Yeah.
Or the district level committee. Yes.
So was it?
No, that was not done. That was not done earlier. So immediately after the DC issued the certificate, the transfer order was issued by the mission director.
No, earlier, okay. Now,
Now we have the issue, the DC has uploaded it, the certificate. Then your lordship, the second part is not. Now,
no, was it considered by the competent authority?
no, till now it has not been. So that part is there.
Considered by the district level?
No, I don't
Not
think
by the
so.
district level. If transfer is to be make within the district lordship, then the district level will. Lordship may kindly see page 32, like page 32 of the report.
No, you come to the definition.
Definition,
Is
lordship,
who is the competent authority?
yeah. That is to show only lordship, who is the competent authority. Page 32.
Either state level or district level. Any on them. 2C defines competent authority to mean state level or district level. If it is inter-district, then I think state level.
Yes.
Otherwise, the district.
Lordship, this is the engagement order, lordship, issued by the mission director in respect of the petition. Lordship, earlier, lordship, an application was made to the deputy commissioner. Deputy commissioner forwarded. On the basis of that, a transfer order was issued, transferring the petitioner to the place of the private respondent in the earlier petition. That was interfered by the honorable court and directed that to redo this entire exercise by following the provisions of section 9 and rule 11 of the rules of 2022. Accordingly, now the procedure has been initiated.
So, procedure order 9, section 9 has 3 stages.
Lordship, may please come to the rule law. Rule is it's a separate book law. Education.
What does rule 9, rule 11?
Rule 11 is the procedure. Lordship, separate window for deputy commissioner for transfer under exigencies and compelling circumstances. Lordship, here, first deputy commissioner, the deputy commissioner of the district shall on receipt of manual complaint or information proceed suo motu in exercise of the powers under section 9 of the Act shall cause an inquiry in any application made immediately. On being satisfied that there is a cause of urgent action and transfer is essential within the district / outside the district, shall open the format PC 001 as at annexure 9.
That is been completed.
That is done. Then 2 is within the district. So here we are lordship outside the district. So here applicable rule is 3. Deputy Commissioner being satisfied that there is a cause of action and transfer is essential outside the district, shall open the format DC001. Noting the endorsement in the format shall send in the online mode. The recommendation to the senior most secretary lordship to the secondary education department, if the teacher tutor belongs to the secondary education, or to the senior most secretary to the elementary education department, if the teacher tutor belongs to the elementary education department. The senior most secretary to the respective education department shall get an emergency alert in the respective registered mobile. Now this part is important, lordship. Based on the deputy commissioner's report, the senior most secretary of the respective department shall approve the transfer and endorse the same to the appointing authority. Now mission director comes in. Immediately the transfer order to a vacant post in the suitable district and school shall be generated and sent to the applicant or the victim or any teacher tutor under threat with intimation to the deputy commissioner. Now this vacant post is necessary, Lord.
Before you come to vacant post, the intermediary position has it been
Complied, Lordship. Lordship may come to my affidavit, Lord.
Yes.
Page 72.
Yes. Yes.
I'm sorry, page 71. Page 71, paragraph 8.
Yes.
As regards to the statement made in paragraph number so and so, etc., the deponent begs to state that after perusal of the Honorable High Court's order dated 13 to 2023, passed in WPC number so and so, and the connected petition being so and so, the application dated 28/10/2022 submitted by the petitioner, seeking transfer to a school in her home district, that is Kamrup Metropolitan or Kamrup district, of the same service category, and also the endorsement by the Secretary to the Government of Assam Department of School Education issued by under order number so and so dated 22/5/2023, approving the proposal of District Commissioner Borpeta with a direction to the SSA authority for issuing transfer order to a vacant post in a suitable district and school. The SSA authority examined and considered the prayer of the petitioner for transfer on the basis of available materials on record and due application of fine, and upon such consideration found that no vacancy is available against vocational teacher retail trade post in Kamrup Metro or Kamrup district in the same service category as prayed for, and that there were two numbers of vacant posts of vocational teacher retail trade in the same service category, one in Bokel High School, Dibrugarh district, and the other in Borthal Doloigao HS School in Morigao district, in which the applicant instant writ petitioner can be transferred and posted. However, at present, both the aforementioned vacancies have been filled up after the date of issue of the speaking order dated 18/7/2023. As she categorically refused to accept the offer to be transferred and posted against either of the two vacancies, needless to say that the vacancies cannot be kept unfilled to the detriment of the students. The authority by letter number so and so dated 6/6/2023 informed the writ petitioner about the statutory provisions and the factual position vis-a-vis her prayer for transfer and requested her to give her preference and consent to join in one of the aforesaid vacancies to enable the undersigned to issue necessary transfer order. In response to the aforesaid letter dated 6/6/2023, the writ petitioner via letter number 12/6/2023 declined to join either in Bokel High School, Dibrugarh district, or in Borthal Doloigao HS School, Morigao district. Instead, the writ petitioner kept pressing for transferring her to a school within Kamrup or Kamrup Metro District, specifically mentioning about the Bejera HS School at Bejera, Kamrup, whereas the writ petitioner was categorically informed by the SSA authority by letter number so and so dated 6/6/2023 that there is no vacancy either in Kamrup or Kamrup Metro District to which the transfer can be considered. In view of the above explained facts and circumstances, the Mission Director Samagra Shiksha Assam is of the opinion that as there is no vacancy available within the district of Kamrup or Kamrup Metro, at this stage transfer of the writ petitioner to any school within these two districts is not possible. However, if in future any vacancy arises in the same trade to which the writ petitioners belong within the district of Kamrup or Kamrup Metro, then she may apply for transfer against such vacancies as per the norm. In this connection, speaking order dated 18/7/2023 was passed by the authority and same has duly been communicated to the petitioners for information. Accordingly, direction issued by the Honorable Guwahati High Court dated 13/2/2023 in the number so connected to petition number so has been complied. These two letters inadvertently lost. This is the speaking order dated 18/7/2023. Though it has been it was mentioned, Lord, it was not annexed.
No, I have annexed in page 63
in my affidavit.
in my
How-
repetition.
Repeatedly from the part. Instructor. I don't know,
So that
belong to a
vacancy,
particular subject. Okay,
Not available.
cannot obviously be accommodated in any other subject.
Yes, that is true.
You also decline to accept
Those two.
those. So now, as and when vacancies are there, they can
That is one option. And the second part, which I just wanted to point out, I'm not making any pressuring anything, but question is that earlier also the transfer order was passed. That was in Kamrup district itself. So then it was a transfer between two persons. That's already
other person is also from the
same. That is why it was done. But that was on the ground that otherwise that was accommodation was given at that point of time. Rightly, wrongly, it was given. Now they came up saying that there is no vacancy. At that time also, it was not a vacant post. I was transferred to another post. And the whole transfer order was set aside and to reconsideration on the basis of the section 9 was only on the ground that approval was. Now that approval they have given. So it could have been done.
earlier who had come, the other person.
yes,
Yes. Yes. There,
You're representing the private response. So your contention before the court earlier was that the procedure has not been followed. The procedure does not prescribe a vacant.
it prescribes law. Rule 11 plus just now that is reading, I'm reading. It is different.
Yes.
Last few lines, Lord, below. I have marked them. The transfer is possible only when vacancies are there, Lord. And that is why she was pointed out that these are the vacancies to give your preference. She declined to go join any one of them.
The rule prescribes vacant. So,
then the second part.
Huh?
The second part they have stated as and when the vacancy arises.
and then when it admittedly the procedure has been followed.
That is now it has been.
Has been followed.
Now it has been followed. Only that I was
And
trying
the
to point
rules
out that
also-
earlier I have been given. Now
rules also say vacant post. And I think it is not unreasonable.
I leave it to you, Lords. Only thing that if they have said that already in their affidavit, when, as and when it is vacant, will be considered.
No, but your threat perception may not be there for that long.
I don't know whether the person will continue till that part. This is the issue. If that is an issue and you are not
How
accommodated,
do you ameliorate the grievances of people facing threat and all that unless the vacant post is there?
Only on the basis of vacancy. If vacancies are not there,
No, but you see, problem is, all the recommendations starting from the DC, the
DC recommends lot. Ultimately, it will depend upon vacancies available or not.
that is okay. But to say that unless there is a vacancy, we can't accommodate, the very purpose of the mandate of the act is frustrated. Mandate of the act is in case of threat or discomfort for
If
women
some- at
employees.
some- if at some point of time, Lords, this particular provision is silenced, definitely your Lordship will prefer to interfere. But as of now, Lord,
Alleged is all right, but these rules are framed under the act. The act does not conceive of any act says therefore 3 layers of or 2 layers of recommendation. DC that the competent authority and the appointing.
I understand your Lordship, but your Lordship is but Lordship, that is the issue now.
if it would have been on,
Earlier we
say,
did it.
any other ground, then I think that is a very correct, that if you don't have a post. Here it is that somebody is being under threatened and wants to leave the place, you don't accommodate, then there is no other option, she'll have to leave the job.
That you must have alternative measures that you are giving police protection.
That in
That I don't-
my humble understanding, Lordship, that is not the issue insofar as the petitioner is concerned. See, only this is Bajara is her local place, Lordship. That is why she wants to get a transfer.
What is the threat perception?
Threat perception, this
If we get the
particular school in Borpeta district is basically in a particular soil area.
This is why we wanted to see the certificate.
That certificate is not given to me, it is directly uploaded in the website.
Is it available with the government?
I can
Yes,
take a
they
print
can,
out.
they can take. Because the DC has inquired and then uploaded it. I cannot,
DC generally recommends, makes that recommendation.
some threat perception must have been there.
What was the threat?
The threat, your lordship, because it was some kind of a sore area. And the woman was at that time pregnant. And she was having the difficulty in coming and going. That was because attending a school from somewhere else and coming back, there was a threat. That was basically the on the ground she has made it. Because it's not specified, but and then subsequently again, the second application was made. At that time, she has given birth to a small child, and then the child was very young. And that is what the threat was there because of the area.
Lordship, may kindly
Since we have heard, let us also have the benefit of going to the DC certificate.
Lordship, may kindly see page 34. This is our application, Lord.
34.
First paragraph, Lordship. My school, so and so, etc., is situated in Sor area,
Sor.
which is 12 kilometers away from district headquarters and not safe for women. It's a general statement. To stay alone near the school. Recently, Department of Police, Corbetta, has arrested a few anti-national activists from the nearby area of my school. I do not feel safe working in that area, and I have informed about it in writing to the Honorable SP Borpeta, DC Borpeta, Chief Minister. So it's not that a specific, she is in fact facing some specific threat law. It's a general
But in the neighborhood,
apprehension.
in the neighborhood, there are some anti-national activity.
That can be there everywhere.
So that is why I'm not making specific. I don't know. It was her application. What exactly is there? I don't know. And the DC, after inquiry, what he has found, we don't know.
But your application does not show any threat perception technically. Health maybe, yes. Minor child, daughter-in-law, but
Safety and security.
nothing much, nothing specific. Yet.
Specific, yes, to that extent, I
That
also
arising
agree.
or relating to your duties to be executed.
Then the second part is also there, which I said, pregnant woman
But that's
traveling.
It's not right, that's medical. You are entitled to take leave. Childcare leave, maternity leave, they're all available.
No, that is there. That is a different issue, your lordship. But the question, there was that was also stated here. It's not that nothing has been stated. Threat was also stated here.
Anti-national activity.
And that your lordship will kindly take up the act also. Since my learned friend has pointed out, let me also point out something. I was taking it very lightly. Let me go in a little bit depth. Not rule, the act.
Yes.
Now 10. 9 lordship has read. Let us read 10. Grounds for seeking transfer. Yes, a teacher may seek transfer only on the following grounds: for change of residence due to marriage, it is not there; for looking after elderly and ailing patients, not parents, not there; for safety and security of female teachers, it is there; and secondly, for treatment of teachers and or their dependents. So this is also one of the grounds, because it has been stated in that letter, page 34, that she was pregnant at that point of time and she required some medical treatment and all. That was also there. So this is not the only ground. Medical ground is also one of the ground which can be taken. So that is why I am trying to point out. And now the DC has given the approval on which ground, we don't know. They will be
Let
the
us
first.
see that if anything is there.
Lord, one page is there, Lord, page 62. It's by the additional deputy commissioner.
So it says it is uploaded.
Uploaded.
What was up?
What was uploaded is not with us.
What was that? Third- Then first, 29, 22nd, 22nd.
SSC.
We have to put recommendation that certificate by C. Approve.
No, Kamrup, no. Borpeta.
Borpeta. Respect of the prayer. By section 9. Is taken on 22nd.
29.
22nd.
So if you
How about it? 90. How about automatically make it 29?
29.
I heard 29%.
Whatever he hears,
No, he heard it will be said.
That is
but your lordship again said 22nd.
We said 22nd. So it's a matter of transfer. 22nd, you have some difficult.
Let it be 22nd.
22nd. The transfer matter.
Marshal.
Look at my senior council acts and division bench look at. May be taken on Monday.
Say that
Long time when this stuff was pending. Monday is not possible, Monday I will not be.
13. 13. 13. 13 is on.
In the meantime,
And it's submitted to the आगे काम. Having
Your Lordship, in this matter, Lordship, notice has already been issued. Petitioner was the master rule worker, Lordship. And
what instructions you have?
Instruction awaited, Lordship. In the similar matter, Lordship, Honorable Court was pleased to pass the order, Lordship. petitioner was initially appointed on 15/5/90. Similar matter, Lordship.
Is it this order? Have a- Is it enclosed to the petition? No.
No, Lordship. It is
We have-
enclosed. I have enclosed, Lordship, Sanjita Roy, Lordship.
You give him one more copy of this
The-
order.
This order.
Do you have a copy?
I will photocopy. Take the photo.
Right.
I'll give them.
Yes. Give him a copy. Give your name.
See what does it.
See what Charlie for
Petitioner.
petitioner, Mr.
KK Mehta for respondent number 6 on behalf of the
Accountant General and for irrigation, Mr. Bora for
Right.
May I please, Lord?
Yes.
Hearing this case, my lord, petitioner is paying for pension, my lord. And your lordship on 4/4/2024, my lord, directed the finance department to obtain instruction, my lord, in this matter, my lord.
Yes.
I have also served a copy.
Sorry. Instructions awaited. What is your grievance here?
My lord, my grievance is for pensionary benefit, my lord. I have already retired from the service, my lord. My prayer is, my lord, your lordship, at page 18, my lord. He is a drop teacher, my lord. Accordingly, this honorable court on 2000, their service have been regularized, my lord. On 2015, your lordship passed the order for regular pension, my lord, in terms of by counting their past service.
Let us have that instruction. Sir, I allow. Get it. Praise for time. Part of you.
May I plead your lordship? Last petition, SC has taken.
Sorry for allotment director requirement to complete the proceeding. Proceeding has been started.
What suspension?
Lordship,
Suspension.
suspension matter, lordship. Petitioner suspended on 11/10/2023, lordship. Allegation is that lordship petitioner has assaulted one of his colleagues, the students of his college in school hours, lordship. Last occasion, they have stated that the report has been submitted within a period of 15 days, as per the last order, lordship. But the said report has not been, lordship.
Report has been then whether the order thereon by
Lordship, 20 May, lordship. 20, lordship. 22, lord.
The medical reimbursement for a lordship expert lordship order
that has been verified and paid him, my lord. Now in petitioner is claiming 7 lakhs. As per our notification, my lord, or as per regulation, he is entitled to only 40 lakhs.
He's not here.
Yes,
Here
my lord.
for the- Yeah. yeah. Seba.
Seba.
You here for Seba.
Seba.
Everything is good.
Have your lordship. But the petitioner is presently serving as block element education officer, lordship. During his service in the month of last July 2023, lordship, an affair has been lost, lordship. Thereafter, lordship, petitioner pending arrest, lordship, he filed a bail application before the honorable court, and bail was granted. Thereafter, he joined in service. As the allegation was serious under POXO Act case was registered, lordship, then Director of Elementary Education caused an inquiry against the petitioner, lordship. The lordship will find the inquiry report dated 18 January 20, page 31, lordship. Page 31. Lordship, kindly see the last two para conclusion. It has come to the notice that the accused incumbent Ravichandra Shield Gabhuru is involved into the allegation against torturing a minor girl who was kept in his residence as a child labor, for which an affair has also been lost and a video clipping published in DY so-and-so channel. The Bebesia Police House registered a case by PS number so-and-so, and stated that he was absconding from service with effect from so-and-so as reported by the Bebesia Police, which is punishable under Rule 9 of Assam Service Discipline Appellate 64. Therefore, the ghost may be requested for no work, no pay under so-and-so, may be imposed stoppage of annual increment with cumulative effect of the increment, and he may be transferred to the district and also want to not to repeat such. This is the lordship suggestion. These were not acted. This is lordship the inquiry dated in the top lordship 5/12/2023, and it is submitted by the DE on 18 January, lordship. And I have been depriving from my salary from August 2023 till date, lordship. I have not been allowed to work, lordship. They can do anything as per their inquiry report, lordship.
Yes.
Otherwise, the instruction is avoided. But your lordship may direct to act as per this inquiry report. By the inquiry.
It's up to them to accept or not accept.
Lordship. Otherwise,
Instruction.
let me have the instruction. Lordship, of course, have to
For
do
the
it.
disposal.
Lordship can either at least up to lordship. I'm not getting salary from last August 23. This is the
You're
problem.
not getting one aspect.
Yes.
Are you inviting a director that the
yes
findings of the inquiry report
Yes.
be imposed?
Yes.
That can't be done. That is up to the authority side. They may accept it.
That is there. They can again the door is open. I will approach this court.
They may not accept, they don't accept, they will give reason prior to that.
But inquiries from the lordship, my only period, lordship can direct to implement whether they are implementing this or not. That is another aspect. But this is inquiry report. Suggestion.
Dispose it.
Yes.
The director. And by the time you serve the order, some other order is passed. On the basis of this, some other, what happens? They have to be certain that government has not taken it.
But that then lordship let them take the instance. In the meantime, maybe direction may allowed to release my the arrears salary. That is stopped from August. That is I am entitled, legally entitled.
On 27/3/2024. Department no instruction. He raised the other end, referring
Yes, 30 lordship. Yes, 30. It is
Annexus 7.
yes, lordship.
Page 30.
Yes, an inquiry report is 31, dated 5/12/23.
Submits that inquiry report to be submitted with recommendation to as indicated in the inquiry. However, it may authorities have not acted upon in inquiry, nor has it have they been that is like he therefore submitted the authority direction. Please send it to
From August.
yes. Since the inquiry has copy their own court is the proper direction for right or steps that they take. Personally, any amount of game respect the that will be taken on 22nd.
Lost. Yes, sir.
No.
Where I report for that, instruction is awarded.
Yeah,
It is
paper.
the paying person incremental benefit.
Increment limit. Since the year 1990 to 2019.
Paying some time.
Okay.
P. Sharma, Standing Council, is for thank you. Of prayer made by MS.
M. Sharma.
Let the matter be listed on 22nd. May.
Okay. Problem.
Forty-four to dispose of.
Here we have filed our affidavit today.
Today lordship, they have filed affidavit lordship. In fact, I am not getting even the provisional pension lordship.
Right, then
And
the matter be listed
any date in
for
the next
action after 2 weeks as the affidavit, counter affidavit has already been filed by the respondents today. Petitioner may file reply.
No reply will require because issue has already been decided in.
Let the matter be listed on 20
I'm praying for next week lordship.
16.
Problem.
Yeah, my lord. Equalization of pay, what happened, my lord? While I was serving as extension officer in Cherikita department in Karbi Anglong, I was promoted along with the other person, the other two junior to me also. But I could not join because that time election was going on that particular time, which I duly admitted by that. That is why, my pay was, increment was not considered as I'm getting less payment. That finance department has filed affidavit to stating that admission department is to take the action on this. They have not received any information to that extent. And in the meantime, my lord, from extension officer to superintendent, I become another next hire to assistant director also. Now also I'm getting less payment, my lord. That is my answer to your lordship, what the Supreme Court is clearly saying, and the reported case is there. Here we are Gulchand Singh Girwal versus Punjab State. Here,
Right, in view of the earlier order dated. Yeah.
affidavit.
Not
Yeah.
filed.
No, the file, I have received a
Filed.
file.
Are you filing any reply?
No, required is a fact. They're not denying.
That the affidavit that is filed.
I think the record I can
Matter be
tag me lord today.
160.
16th of
May.
16th of Maybe your lordship, today I think we get it. It can be disposed of today also because my learned friend has told is under consideration. If so, that my learned friend, concerned department has said, this is it is under consideration.
You have so many learned friends. Which
Nay, last learned, my friend, agriculture department. I'm just showing like this, you know, that's the end. If under.
I have received a WhatsApp message, my lord, that is they are examining, department is examining, and it is under consideration now. So that is the instruction, my lord, in
Yes.
WhatsApp that I have shared with
That will work out, my lord, till
consider
16.
and pass out.
Yes, that must will work out up to 16, my lord.
I don't know this will- if only that consideration part, my lord. We are considering.
No, maybe fixed
Where
today.
where is the affidavit filed by the respondent?
Agriculture department. Yeah, my lord, finance department is my lord. Your lordship will get, that was filed.
They have said no proposal for equalization received. Page 43, para 5.
Exactly, my lord, so we are communicating with finance department, and my lord,
Finance department is saying. Correct. Agriculture is not filed.
Finance.
Finance is filed, my lord, lordship. Yeah,
agriculture.
that was filed on 8/3/2022 itself.
Para 5.
That's why, my lord. Yes, that's it. They are waiting for their,
My lord,
according to them, my lord, admitted here, my lord, with regard to statement made in paragraph so, to state that finance department examines proposal of equalization to pay received from the admin department,
Later, lower in the paragraph.
lower paragraph.
However, no proposal.
Yes, however, no proposal. That's line to from where it is been.
Has been received.
This
So it is only upon receipt that the finance will decide what is to be done.
Definitely, they let them send it to the department.
my
So
lord,
if you want the petition to be closed, we can only order that they will send it.
send it.
Lots of pleasure. If it is my basic purpose, is my consideration is made out. Then nothing to nothing. Why? Because it is I am working under them only. I have to work till my retirement.
Tell
That is
me-
why, my lord,
you tell
till
me
my submission today, my prayer may be this way, my lord, that Lord may fix on 16th, my lord. In the meantime, they may
That was
consider.
not your prayer earlier.
No, it was, I mean, now it can be rectified, modified.
Then, my lord, my prayer is, my lord, it may have come up with 4 weeks, my lord. That is what the written
4
instruction
weeks.
that I have. Department,
4 weeks.
But then they have to go by Supreme Court judgment, 18% interest.
that part my,
We'll give you 3 weeks.
my,
3
my,
weeks. Then matter should be listed on 29th
Fine.
May.
29 may not be, my lord, sir.
You're not here.
26th,
Then
26th, my lord. Or 3rd June.
on 26th, I am not coming.
3rd June?
3rd June.
Yes.
3rd June we can.
Got it.
Matter will be listed on 3rd of June. By which day the respondent will apply the court status of it will set the petitioner that the proposal of respect of the claims of the petitioner stated will be sent to the concerned department. Please report it. Give your names, please.
my
Give
lord,
all
I
the
have
names. Right.
asked for 1 and 2.
Lordship, here in this matter, the petitioner has filed a reply yesterday, Lordship. And Lordship, similar matter was listed today, Lordship, in court number 2, Lordship. Lordship, let these 2 matters be taken up together, Lordship.
In fact, my lord, it's regarding non-payment of salary, my lord. In fact, they have admitted the fact that, my lord, they will pay, my lord.
Yes, lord.
So in the affidavit, my lord, your lordship may say, my lord, at para 4 that, my lord, the area salary will be paid to the petitioner as and when funds are
There are
available.
4 of what? Their affidavit.
Yes.
In affidavit in opposition, my lord,
There are 4.
by the
Page 40,
respondent number 3, page 40. They are not disputing my appointment and, my lord, they are agreed to pay. Para 4, my lord, last 3rd line. The area salary will be paid to the petitioner as and when funds are available. So this is cannot be the ground, my lord, for holding up my payments, my.
So let them verify and pay, my lord. Only 6 months
They say that June to October, December has been paid.
paid, man.
Huh.
Only now 6 months payment is, my lord, held up. And that is, my lord, as soon as, my lord, they have
And
fund,
who has filed this reply
Lordship, this.
reply by me, my lord.
stating
That, my lord, I have stated that, my lord, during pendency of this case, my lord, they, my lord, released the payment for the month of March, my lord. So in that view of the matter, 6 months is left out, my lord, now to pay. So otherwise, they are agreed to pay, my lord. Let them verify and, my lord, pay,
Yes,
my lord.
Lordship, that can be.
they, how many, there are two parts on this affidavit. I don't know, but there are two reply affidavit.
In fact, my lord, probably one has come wrongly, my lord. That should go to that court. That is one should be, my
One
lord.
is in WPC 1727.
Here, that is 1727. Yes.
And the other is also in WPC 1727. But your paragraphs are different. I think subject to correction. Okay, no, it's a second copy. Yeah. Third Learning Council for the participant for area salary.
Yes,
Yes,
madam.
Amounting to rupees 4,58,665 in respect of the petitioner towards the services rendered as a staff nurse in the National Program for Healthcare of the Elderly, the Guwahati Medical College and Hospital. So, petitioner is agreed that the monthly area salary for the services rendered has not been released in spite of several representatives. So, whereas the respondents have filed their affidavit, more particularly respondent number 3 has filed their affidavit. Stop at para 4 of the affidavit. It is stated that area salary from the months, 40 months, June 23, December 23. has been Stop. The further area salary will be paid to the petitioner as and when the funds are available. Whereas, Learned Counsel for the petitioner submit that there is no dispute with the petitioner. There is no dispute regarding the petitioner's entitlement to area salary. So, however, the stand of the respondents that area salary shall be released only upon funds being available is wholly unjustified. So, if the petitioner is found to be, if the petitioner's claims are found to be if the petitioner's claim are found to be justified, then the area salary is to be forthwith. So, Para. Learned counsel for the parties have been heard. Pleadings have been perused. It is seen that the affidavit filed by the respondent number 3 clearly states that the salary, area salary shall be released to the petitioner as and when funds are available. And thereupon, area salary for the months June 23, December 23. So, perusal of the said affidavit does not reveal anywhere that the respondents have disputed claims of area salary. Under such circumstances, we do not find it necessary to keep the litigation pending any longer. Stop the litigation stand disposed of the direction of the respondents. All the respondents to take all steps necessary for release of the area salary, monthly salary payable to the retribution. If the sufficient funds are not available with the respondent number 3, the necessary proposals thereto shall be made by the respondent number 3 before the competent authority. Before the competent department, and thereafter, as and when such proposals are furnished, the department will ensure that necessary funds are placed at the disposal of the respondent number 3 for release of the area salary. With the above observation, it stands.
My lord, this
The
exercise
entire
shall be, my lord,
exercise shall be completed within a period of 6 months.
my lord, that can be, my lord, some trouble, my lord,
4
because
months.
3 months, my lord.
4 months. Lordship.
3 months because
And Lordship for the month.
1 month will go like that.
My
Make
lord,
it 4 months.
petitioner is suffering, my lord, otherwise no,
He's getting a current salary.
no, my
No,
lord.
Lordship.
They
because
have
he-
already been released, my lord, from the, my lord.
Released.
Yes, my lord.
And Lordship for the month of
Then
March, it has
the
been paid.
exercise be completed, petition within the outer limit of 90 days from the date of the
No.
certified.
My lord, your lordship, one thing, my lord, the area salary total, my lord, that is 4,79,833 because some, my lord, benefit has been held up.
Put a proper petition.
Yes, yes.
In fact, in additional affidavit, I have stated the fact. So in that event, my lord, 4,79,833.
4,79,833. In bracket as taken.
Lot.
Yes.
And be
After
produced. And you.
That page also. So in this case, my lord, kindly peruse the office note dated 18/3/2024, my lord, where whatever, my lord, the already lordship order is there, my lord, to strike out the name of the respondent number 4, but registry did not do so, therefore, my lord, my case has come for orders, my lord.
Noted.
18/3/24. And lordship order was there, is there, my lord.
59. 83. No amended for right.
Yes.
You have filed an amended for right.
No, actually, whatever, my lord, there is an order, lordship order. 30/8/2023, my lord.
Yeah.
Second pair, on pair of the learned counsel for a petitioner, the name of the respondent number 4 be struck off from the cost title of the present petition.
Yeah.
May be allowed to, if it is possible, my lord, I may be allowed to strike off his name by hand, my lord, by putting my signature.
Why don't you file amended for right? Because it has to be updated to the CI. Your handwriting will not make it difficult. In terms of order date 3/0/2020, name of the respondent number. Petitioner filing that was like the rates on week. Image
J. Bathari.
J.
Bathari.
I. When it comes to appeal.
Seba.
Seba. This substance,
Raised you into so much.
you file it before raise. Amended post title.
Yes.
Showing the names of respondents 1, 2, and 3. File it.
Only that part is right. Yes.
Only those parts.
That part.
Yes.
With regard to the review petition, regard to that order. Yes, my lord. And to be tagged along with 61 of 2024.
Taken by registered.
My lord, maybe tag along with
With the review petition listed along
60
number
61 of 2024.
61 of 2020.
Yes. Much alone.
appears to be right. It's- it's-